everybody, and a very warm welcome to the third episode of the Legal Wednesdays. For those who were not able to join us in the last 2 weeks, we had earlier Mr. Vijay Sondi and Ms. Malvika Rajkotia, both highly renowned and eminent lawyers of the country who spoke about the legal rights of women and with a special focus on separations and divorces by Ms. Malvika Rajkotia. Today, I am both grateful and delighted to welcome Ms. Divi Dutta. Divi is a partner at Amarchand, Mangaldas and Co. And she specializes in corporate law as well as private client practice. Divi has, to her credit, a number of high net worth individuals whom she has advised on succession planning and writing and execution of their wills. So what we will hear from Divi today is going to be absolutely invaluable and very beneficial at some stage of your life. Talking to her today is Bhavna Vedhara. I always spell that wrong. Sorry, Bhavna.
That's okay.
Vedhara, I got it. Bhavna Vedhara, Chairperson CII-IWN, and the person behind the whole concept of bringing this very critical issue to the forefront for all of us. So over to you, Bhavna. And Divi, thank you once again.
Thank you, Meenaji. Always a pleasure to be here.
Thank you so much, Meenaji. That was a wonderful introduction to Divi. And Divi, we are so pleased to have you with us today. Thank you so much.
Thank you. Thank you, Bhavna, for having me here. As I said, always a pleasure to be here.
Wonderful. So Divi, I know we've talked about, we've got to get into the nuts and bolts of it, and just understand the wills, inheritance, how it all works. But I think basically the first thing I want to tackle is why must we actually make a will? What is the real necessity and importance behind that will? Divi, can you start with that, please?
No. So absolutely, Bhavna, I think you hit the nail on the head as you spoke about nuts and bolts. I think this is, the biggest nut that one needs to, fix in their life. So a very good question. Now, why you need a will, I'm going to take you a step back. So typically, as you know, we live in an Indian patriarchal society, where properties were just transferred, to generations. And, until at least 5 to even 10 years ago, nobody even bothered, to make a will. The repercussions of which, in fact, I'm very, sad to say a lot of our clients are actually feeling right now. So there are certain thumb rules, that we need to follow. And there are certain reasons that I would like to highlight, easy reasons, but going forward, we do realize how tough they can become and how life can get much simpler if you have a will in place. So I think the most important reason that one should make a will is that it can go to the person who you rightfully want it to go to.
Absolutely.
Right? So in fact, now, because, we have this new India age where, people even at the age of 30 and 40 are actually able to buy properties. They are able to invest a substantial amount, of their earnings. They're able to buy real estate, mutual funds. Everyone has become wise about the ways of investing. Now, investment is, of course, really good. But what happens, to your children, to your wives, to your husbands, to your cousins or whoever else you want to give it to if you don't have a will in place? Now, the law try to help you to an extent that if you die without a will, there are certain classes of heirs which, we can talk about, later.
Sure.
But let's say if you want to give a substantial portion of your wealth, say only to one child or only to your spouse, the law does not let you do that. It's a will that actually lets you do that, because a will is exactly what it is. It's your will, right? It's your wish to give your assets to whoever you want to give. So that's actually the biggest reason why one should actually, do a will. It's not very difficult at all. We'll talk about, how one must make a will later on. But the most, important reason for one to do a will is that, whoever you want your assets to go, whoever you want your hard-earned money to go to, you need to write that down in a will. So, so that is, of course, one reason to have a will. The second one is also that you don't want to put your legal heirs, through the struggle of running from pillar to post to get your assets.
Yeah.
While you may simply just have a wife and a child and you anyways want to give them everything. But then what happens is that the minute someone dies interstate, there will be relatives, who'll be coming to claim a share. There'll be somebody, a long lost person who suddenly comes and says, your father or your mother owed me this amount of money. They'll bring in some kinds of documents and things like that. Then you also need to prove it under law that you are actually the legal heirs. Then you need to actually go to court and get a succession certificate to be able to prove that you are the successors. You may need to go and get a legal heirship certificate. So all of that is an exercise in itself. At the same time, you will also need that kind of documentation to prove that you are the legal heir. So what say you're not able to, get that documentation? What say the court is not satisfied? If someone raises an objection, you actually will not even get what you rightfully should have from your fathers and forefathers.
What is the documentation? I'm just going to interrupt you here because you mentioned, what is the documentation that would be required to prove that you're a legal heir?
So Bhavna, let's assume my father has died, right? So I will need a documentation like a birth certificate, which basically somewhere says that he's my father. Like nowadays, a passport is something that they accept because that, clearly has your mother, father, and your spouse's name. The most important, of course, would be, let's say a PAN card. Preferably, proof ID is issued by the government of India that clearly after verification, have written that this is my father's name. So those documents. But we also know India, we do have a lot of people who are unfortunately not very educated. We do have a lot of people who may not have, had these documents or checks and balances in place, or the documentation may differ, like the spelling, for example, the most important or the most common mistake that people make. The spellings in the father's name are different. People don't bother to change it. So all of these things later on can become big issues. So if you want to avoid all of that, another interesting example that I want to give is a movable property.
Right.
The minute people in your family, your staff, the minute your relatives know that, somebody has died without a will. I've had instances where during funerals, people just pick up the movable assets in the house and they go away.
They just nick them.
They just nick them. And there is no way for you to prove that this actually belonged to me. But if it's documented in a will, there's obviously that kind of a proof. And also, if you have a will in place, nobody, it's a bit of a deterrent that nobody will be able to do this as freely as they would otherwise. So these are the number of very simple but very relevant reasons why one should actually have a will in place. And mind you, a will is extremely simple to make. So it's not something that, you need to go to a lawyer or a chartered accountant or even to really big advisors to make one. You can do that on a piece of paper at home. So I would actually strongly recommend to everyone who has at least one piece of asset in their name, even something as small as a fixed deposit, please make your will.
No, fair enough. I think those are all key points. I just have a quick question on this point before we move on to the elements. But tell me, let's say somebody passes away. Would you also be able to name your legal guardian through the will, even if you don't have maybe if you haven't set up a separate trust and executor for them, would you be able to do guardianship through the will, or is there another thing that would be required?
So Bhavna, it works in two ways. One is, of course, the legal guardian. So typically, as you know, under the Guardianship Act, it is the mother who's the natural guardian until the child is 5. Post that, it is the father. So let's assume that the mother and the father both are not alive. One way of doing that is, of course, you nominate a guardian, but at the same time, you need to get that will probated by the court, because the guardian who is not a parent has to compulsorily be approved by the court. A second way of doing that, if you don't want to get into that hassle, is that you trust your executor. So you can actually direct your executor to hold on to the assets, for the benefit of the minor, and only pass it on once the minor attains the age of 18. Until that time, your will can clearly give the executor the power, not as a guardian, but as an executor, to hold assets, to look after them, to reinvest, maybe give out a certain portion, as and when required, but just transfer everything once the minor has attained majority. And that need not only be 18, let me add. We've done wills where people don't trust their children to make decisions. So the assets only get passed on once, say, the child is 30. So there is no, particular age where you want assets to be passed on. It can actually be at any time.
Wonderful. So I think these are really key areas. And I'm just going to sum up my takeaways. I'd say safeguarding your assets per your intentions.
Yes.
I would say preventing disputes post your demise.
Yes.
The third one would be that proving, there's so much to be proven during this whole process that, if we can just make it easier some way through the will, I think it would be prudent. Thank you so much, Divi. Now, what are the must-have elements of a good, clear will that can, hold up in court? Can we go over that, please?
Yes. So in fact, the must-have elements or the thumb rules are actually very few. So typically, and I've also seen someone has raised that question, which is anyways what I was going to say, you don't need a will to be on stamp paper. You can actually have a will on a plain piece of paper, whether typed or handwritten. Any of those wills are admissible. Only thing is what you should do, and the thumb rules or the important points of a will is that you compulsorily need to have two witnesses. Because
Right.
these are the two witnesses who will actually prove your will. Let's say if tomorrow it has to go to a probate, or if there is a dispute, or if someone alleges that this is not your, your signature, or you were coerced, it's the witnesses' testimony which will actually help. So you
Right.
definitely need to have two strong, impartial, independent witnesses, preferably who should be younger than you, so that,
Yeah.
when you pass away, they are still alive. So one of the thumb rules, of course, is having two witnesses to your will. That is the basic point, thumb rule. Second
Yeah.
is having a good executor, because there
Mhm.
has to be someone who will carry out your wishes that you put in the will. You may just write, I want to give A to B and B to C and C to D, but there has to be someone on your behalf who can actually carry these transfers through. So A, you need to have two witnesses. B, you need to have an executor who will carry out your wishes. Third and most important is that you need to have a clear description of your assets. I'm not saying these need to be lengthy descriptions. You don't need to attach sale deeds and things like that. But let's say if there is a bank account, you at least need to put the name of the bank and your bank account number. Because other
Right.
than that, if you don't put that, even your banker will not, transfer the contents of the bank account. If there is a law, yes.
Yeah. No, here I just want to ask you, because often we have nominees,
Right.
when we have nominees, but then what if that person, for example, let's say I make a will. In my will, I leave everything to my immovable assets to my children. But in my nominee, I've given it to my husband, let's say. So
Yeah.
then can he just take it and that's it? Or like, is he, required to give it? It's a lot of trust, isn't it?
It is. So Bhavna, I'll just complete these 4 points, because the nominee actually is a different issue, which anyways, it's a very good question, which I want to address, because,
Okay.
that is a mistake that, most people make. But other than that, yes, I mean, if it's a locker, you need to put the locker number, so you should have as clear or, a description of your assets as possible. And
Yes.
last but the least, don't try and complicate your will. Don't try and give things over 5 generations, don't try to make things so complicated that is difficult, for your executor or for anyone to
Hmm.
understand. Just try to make a will, as simple as possible, because the beauty of a will is that you can make multiple wills in your lifetime. A lot
Yeah.
of people think that's not possible, so they try to jam in, everything into one will, thinking, what about this, what haves, happens, and all of that. But, do not do that, because if it's not a simple will, then it's bound to get into further disputes. And of course,
Mhm.
as I said, you can actually keep changing your will, because your asset base is not going to be the same as it was, right, when you first, do a will. So you can
Absolutely.
keep changing your will. So definitely keep it as simple but as clear as possible. Now, Bhavna,
And
coming to,
current. Yeah.
yes, and correct. Now, coming to the most important question, this is in fact a common mistake that a lot of people make. So typically under law, a nominee is just supposed to be a custodian. A
Hmm.
nominee is not really the owner of the asset. And there are multiple jurisprudences and case laws that actually state, that the legal heir, if someone, has got those assets, someone is a notified legal heir in a will, it's
Right.
actually they who have the right over the asset and not the nominee. But the issue that happens is that for banks, most banks and financial institutions, they go by the nomination that is provided to them. So what a nominee, the power that a nominee has is that you don't even then need the will. All you need to do is submit a death certificate, and then you can actually get the asset transferred in your name as a nominee. So if the nomination is different and the legal heir is different, then the legal heir actually has to go, either, of course, if the nominee would easily transfer to the legal heir, that's the case is very few and far beyond.
Correct. Correct.
But
That's what
you
I
get,
was getting at.
yeah,
Yeah.
get the
Yeah.
nominee to transfer it, then again, you have to go to court. So which is why that is something, again, which is actually an important message to everyone who's listening to this. Please ensure that your nominations are actually correct. And please ensure that there is as little discrepancy as possible between your nominee and the person who's actually receiving the asset in your will.
I think that's, yeah, very important. So thank you so much for that. So witnesses, keep it current. I think we've got all that. It doesn't require a stamp paper. Okay. Now, how does one prove the existence of a will? Is there a specific way that we would go about this if it's not registered or something? Because I know that this is, this was a question that people asked me to ask you, and I said, okay, is that really? But they said, no, no, no. How do you prove the existence of a will? I said, okay, I will ask it then.
So Bhavna, that's a good but an extremely unfortunate question. Because if a will is not registered, and let's say nobody knows, where the original or even a copy is, it's next to impossible to prove the existence of a will. Because nobody is going to go on your, testimony or on your, version that I knew there was a will and I knew the will said ABC if you can't produce the actual will.
But then, Divi, that's why you would say, now register the will.
So
because that's how you prove it, right?
No, that's not something I would say. I would definitely say registration, but for different reasons. In terms of proving the will, what we typically suggest is that you definitely should give a copy of your will to the executor once you've signed it, even if the executor is not a beneficiary, because he or she is the one who's actually going to give effect to your will. You should definitely give a copy of your will to your legal heirs. If you're anticipating a dispute, then of course don't, because one will know what the other is getting. But you should then also give a copy to any of your trusted advisors. Let's say you have a trusted, lawyer or a trusted chartered accountant in the family, or a trusted friend, so we typically, in fact, we even get wills executed in more than one original, just in case if, one is misplaced. So one you keep with yourself, one you definitely give to your executor. You can actually keep one, in your locker where your wife is also a signatory, or give one to a trusted friend. So that is safeguards, one can do to ensure that, your will actually does see the light of the day, and that, your will, the existence of your will is fairly protected. But coming to registration, let me take you, through the legal jurisprudence a bit. This will take a bit of time. So typically in India, there are 3 states where a probate is mandatory. Now, those three states are West Bengal, Tamil Nadu, and Maharashtra. So anyone who either lives in any of these 3 states or has immovable property in any of these 3 states, they compulsorily need to probate a will. Now, when you probate a will, your will gets a stamp of approval from the court, right? So that is something that in any event that nobody can challenge, because the court has approved the wishes of the testator. But there are a lot of other states, like such as Delhi, for example. I'll give you an example closer to home. Because there's no requirement of a probate, there are a lot of times, where there are a lot of challenges that people face in terms of getting the will executed or getting the will acted upon. Because banks and financial institutions, are reluctant to act on a will because they may anticipate it to be disputed. So to avoid that, avoid these practical issues, we also recommend that it's better to have the will registered. Because when you have the will registered, you eliminate any challenge that it is not signed by the testator, because you typically sign in front of the registrar. It eliminates the possibility that you are not of sound mind, because the registrar takes it on video recording that, have you signed this will? Are you of sound mind? Do you understand what is written, and things like that? And that's recorded at the registrar's office. Secondly, it's also proof, that you have signed this will. These are your wishes. Your witnesses, were there, because the witnesses also have to sign at the registrar's office. So all disputes get mitigated if a will is registered. And of course, to top that, any bank or a financial institution in states where probates are not mandatory are more likely and easier to act if a will is registered rather than an unregistered document. So these are the reasons why we also recommend that a will is registered. And of course, coming to your existence point, yes, in case if you ever lose a copy of your will, you can actually get it from the registrar's office. You can get a certified copy from the registrar's office. So they also have a record of your will. So it's actually helpful to have a will registered. I mean, there is no downside to that at all.
Right. No, thank you for that. I think it was more like, in case people conveniently misplace a will, then how do you prove its existence? And you've covered that beautifully. So what all can be willed? And here, if you can touch upon, self versus inherited ancestral properties, HUF, all of that, joint, single assets.
Right. So honestly, only what can be willed is your self-acquired property or property that is actually standing to your name. When I say self-acquired, it is actually property that you've, bought with your own money. That is property that you're the rightful owner of, and property that's in your name. The other property that you can will is property that, that may have been gifted to you in your lifetime by your parents, by your siblings, by your spouse, but which again, you are the owner of as on the date of writing the will. The third kind of property that you can will is property you may have inherited from your parents or your grandparents, but where such property is not an ancestral property. It's an inherited property. So let's say your father has a self-acquired property which he has passed down to you through his will. Then that property actually becomes your property, right? You're the sole owner of that property. So you can definitely, again, will that property. Now, in terms of properties that you can't will, one is, of course, ancestral property. When I say ancestral property, it is a property which has actually been in the family through more than 4 generations, and it actually passes down by birth. So the right that you get in an ancestral property is through birth. So tomorrow, even if I don't want to will it to my sons or to my wife, and I want to will it to a third person, I cannot, because my sons and my wife actually have interest in that property due to birth. So ancestral property cannot be willed. Second is HUF. As you very rightly said, most of the Indians have Hindu undivided families, right?
Yeah.
Where the main person, where the father is actually the karta. So while the property may be in his name because he's the karta, while he's operating the property, he's managing the property, but it is not his own property to will. In fact, each of the co-partners, by co-partners, I mean each of the members of the Hindu undivided family, they all have an equal share in that property by birth. So that is also not a property that you can will. The third kind of property that you cannot will completely is a jointly owned property. In a jointly owned property, you can just will 50%, which is your share, or whatever is your defined ownership share in that property, but you cannot will the entire property. So what the common mistakes people do is, they get a property, signed in the name of themselves and their spouse, right? It's a jointly owned property, but they actually feel is their property to will. It's not. If a share is not mentioned, then it's an equal share, or if it's a share is mentioned like 40, 60, 70, 30 or whatever, then you can only actually will the share that is yours.
Right. Okay. And you had shared a story with me, Divi, I know, about the perils of joint properties. Would you mind sharing that now? You had shared a story, remember, of the 3 assets and the equalization and how.
Yes. So in fact, this was an interesting question you had asked during our, informal chat. So let me actually give our viewers a background on what the question was. So what Bhavna had actually asked me is that, is it advised? So let's say we have 3 properties and we have 3 children, right? So is it advisable to give 1 property each, to every child, even if it's different in valuation? Or is it more advisable to give every child a share in every property, like 33%?
Yeah.
Just to ensure that each of them get a fair balance in your will. So this is something.
It was a fear, addressing the fear of parents, where they feel like the fear of one child, losing out. That was the driver. And then you shared this wonderful story. Please carry on.
Yeah. So in fact, I had told Bhavna that it is definitely not advisable to give all 3 children an equal share in 1 property. Because typically then what happens is that it's very difficult to share 1/3 of a property, right? And also at the same time, the story I had told her was that, let's say in a flat, you have 3 rooms. So by a 1/3 share, I'm actually entitled to 1 room. So then the first dispute starts from there, right? So let's say if all 3 kids want to stay in the same room, in the same house, which room are they going to choose? So that's the first set of disputes. The second set of disputes is if 2 people want to sell, but 1 doesn't. I mean, nobody's interested in buying 2/3, of a flat. So in fact, more or less, even if they don't start out as disputes, typically these situations always end at disputes. So the way to work around this is that, while you should definitely equalize the shares of every child that you have, the other ways of doing that is, you can, will one property to them with specific directions to your executor, to have the properties valued at the time of death. And then whatever the shortfall is to any child, that can actually be made up, by way of other assets, either monetarily or by way of mutual funds, and things like that. So that is a better way of equalizing, because even every child has an ownership, a complete ownership of a property. So they can do with it as you please. Similarly, if you want to will your 33%, even if that generation does not have an issue, the next generation, might then have an issue, right? Because your children might not get along. So ultimately, even your children are just getting 33 property. So to reconcile that difference generally becomes very difficult.
Yeah. No, and it's just fraught with issues. So I think that that was the point I wanted to, bring out, that a lot of people as parents, we want to always do equal, and we don't want to take that decision. So we think we're doing the right thing by just giving half. But what we don't realize is actually we're setting up messes for the future, really,
Right.
for them. So, okay. So now, can a will be challenged, and if so, in what ways?
So
And is
Bhavna,
there a
the
statute
answer,
of
yeah,
limitations around that? Yeah.
okay. So the answer, of course, the first answer is a big fat yes. Oh, can definitely be challenged, no matter how many safeguards you take. No, whether you, I know a lot of people attach doctor certificates, a lot of people handwrite it, a lot of people get it registered, but that does not stop anyone from challenging the will, right? Ultimately, anyways, it would be the court who will decide, but that will still take you into years and years of litigation. So the answer to that is definitely a will can be challenged. We see a lot of wills which we think are airtight, but still are challenged. So ultimately, yes, a will can be challenged. There are, of course, ways that you can mitigate a challenge, as I spoke about. One is,
Yeah.
of course, registration mitigates the challenge to a huge extent. It mitigates the actual drafting and signing of a will. It may not be able to mitigate the contents. I'll come to
Right.
that in point number two. But as I said, it mitigates the fact that nobody can say that the executor did not sign. I'm sorry, the testator did not sign the will, and this is not his or her signature, because they
Right.
actually signed the will in front of the registrar.
Right.
Nobody can say that that they were not of sound mind, or nobody can say that they were coerced, because they go with the witnesses. So it mitigates it, but people can of course still say that they were coerced, but it definitely
Yeah.
mitigates the challenge. Another way to mitigate a challenge, of course, is to get the will photographed and videographed while you're doing it,
Mm-hmm.
just to prove that this was the person who was signing the will. This was the person who actually signed it in the presence of witnesses, and things like that. Another thing that we typically suggest, at least for people who are generally of old age, is to attach a doctor's certificate,
Is
with
to
a
attach a
doctor's certificate.
doctor's certificate. Thank you.
Yeah. So at least a doctor can actually, just check the patient on the day of signing the will, and
Yes.
actually certify, that the patient was not suffering from any mental illnesses. The patient was coherent. The patient could understand what was being spoken to. The patient could sign. The patient was clear-headed at that point of time.
Yeah.
The
Sound
patient
mind.
yes, of sound mind. So, that is also one of the safeguards, of course, that one can take. So these are the typical safeguards that we do. And of course, please ensure that every page of the will is initialed. If a will runs into pages, the testator should ensure to sign each and every page of the will, not just the last page. If there are annexures to the will which give a description of the property, please ensure even those, each and every single page is actually signed by the testator, so that tomorrow nobody can replace pages if it's an unregistered will.
Right. Tell me something. What about if you got the legal heirs to initial the pages, or is that not a done practice? So that
No,
they
it is a
know.
Yes, no, I agree with you. So it is a done practice, and it's also a practice where you feel that your children might get along now, but at a later stage, you may feel that there may be disputes, once you're not around. So what
Yeah.
people also do is, just to ensure that none of the children can actually say that, this was a fraudulent will. Sometimes people even get their children and their spouse to initial every page along with them, just to basically state that no child can then raise an objection, on the fact that there was a will, because they knew the existence of that will.
Yeah. Yeah.
Coming to challenges, Bhavna, one more point is that apart from challenging the existence or the manner of drafting or signing the will, you can also challenge the contents of the will. So we have seen situations, where you can actually challenge what is written in the will. One of the most common grounds is, that the property is not yours to will, for reasons I already said earlier, right? If it's
Yeah.
an property, it's an ancestral property, is jointly owned. So definitely you can challenge the actual bequest. Another one of the reasons that you can challenge is that contractually, I may have already agreed with someone that, post my death, I will give you, this portion, and then you will it to somebody else. So the person who's part of that contract can actually challenge the bequest in the will. So that is also, something, that's also a reason, for a challenge. So there are other challenges also that one can put. Some may just say that, the content is wrong, while you may, which is why I said a will should be as simple and clear, because someone may just challenge the interpretation of the will by the executor if it's a fairly complicated will.
Yeah.
So these are different ways in which, a challenge can come out.
Wonderful. Thank you for that. Now let's come to, in the event a person dies without a will, interstate. So can we talk about the properties, how they go, how they get distributed, and then, the classes of heirs you mentioned, and what happens if there are no legal heirs, or they don't, they never got married, they just died, without any legal heirs. Then what happens to these,
So
all
for
the
this,
situations?
yeah, go ahead. Sorry.
No, just all the situations, So if you die interstate, what happens to your legal heirs? If you die without any legal heirs, what happens really in that way?
So Bhavna, for this actually we'll have to take, fortunately India's, very diverse country, where we have, people who are actually allowed to practice different religions.
Yeah.
So given that we don't have a uniform civil code, there are different laws actually surrounding interstate succession by Muslims, interstate succession by Parsis, and there are of course laws surrounding interstate succession by Hindu, Buddhist, Sikhs, and Jains. So typically, let's talk about the Hindu, Muslim, Sikhs and Jains first. So in that case, there is a class of legal heirs that are actually defined under law. So what happens is that when someone dies interstate, under the Indian Succession Act, you actually have classes of heirs. So for example, if it's a male who has died, then the first option is your class 1 legal heirs, who will actually get an equal share in your property. Those class 1 legal heirs are the mother, the wife, and the children.
Okay.
They have equal share in your property. Mind you, if it's a woman who's passed away, there is no mother. The mother is only there if it's a male, who's passed away.
But if it's a woman, then it's your spouse and the children in equal share?
Yes, yes. Whoever are your class 1 legal heirs, if they're alive at that time, then they all get an equal share. Now, assuming that none of them are alive, then of course you go to class 2. Class 2 is of course then you move to extended family, which is your siblings, your siblings and your father. So
right.
By saying that, so the law actually has as much as 7 to 8 classes, which ultimately also include stepchildren, children born out of wedlock, or nephews, nieces, and their children. So actually, the law has really tried to cover all your relatives and try to give you as many options as possible, especially for someone who's died without a will. But let's say assume that you die a bachelor, right? Let's say you die a
bachelor, right?
Or a spinster, and your parents have also passed away.
Yeah.
As in your case, and you don't have any uncles or aunts, basically you don't have any family. So honestly, in such a case, anyone, any interested party, whether it's a friend or, a far off family member, can actually approach the court, to say that, look, there is no existing legal heir, these are the assets, and this is proof that that person has died, ask seeking directions from the court. If it's, of course, if you can prove that you're a distant legal heir, the court, most situations may grant you access to that property. But let's say if there is no distant legal heir, then of course the court takes that choice, and the court can take possession of that property by appointing a receiver who can then utilize the property for the benefit of society.
Okay, got it.
But as it's a very remote situation, it happens, of course, but it's a very remote situation that there is no distant relative around. You may not have immediate relatives, but trust me, when someone dies, your long forgotten relatives are the first one who come on the scene.
Especially those who know that you don't have a legal heir, right? They're all coming out of the woodworks. Thank you for that, Divi. What are the tax?
So in terms of Muslims, again, the law is fairly the same. Of course, the classes of heirs, are different. Like Muslims give a lot of importance to women. So your first class of legal heirs, basically will be your mother and your daughter and your wife. So things like the Muslim laws, but the conceptually is the same thing. So if you die without a will, the law generally gives certain classes of heirs, who the property should ideally go to.
Okay. And similarly for Christians, Parsis, everybody?
So
or may not have their own.
Oh yeah, but each of them have their own, laws governing, their intestate succession.
Okay. Divi, what are the tax implications imposed on a property or assets passed through a will?
So Bhavna, the best news is there are no tax implications. So let's say if you have willed an immovable property, there is no stamp duty implication on transmission. If you have obtained any kind of property from anyone, currently at the time when you inherit the property, there is no tax or stamp duty implications. You may, of course, have to pay some nominal processing fees and things like that. The only tax implication comes is when you generate income out of the property you inherited. Okay. So if you've inherited a bank balance, right? Or if you inherited fixed deposit. But post the date of inheritance, whatever interest you receive, you will have to pay tax on that, but not on the actual inheritance that you've received. Similarly, that's also a reason why most people prefer to will their immovable property rather than gifting it in their lifetime, because there is a huge stamp duty implication even on gifts. But if you will it to your legal heirs or to anybody else, there is no stamp duty implication or tax implication, on transmission, as we call it.
Okay, wonderful. No, I think that makes a lot of sense. That's why, willing it is the right way. Apart from that, also just, you want to have it so that you're safe during your lifetime, because you don't know if your kids are, whatever happens or what. I mean, it's just good to safeguard yourself through your lifetime.
No, I'm very glad you brought this up, because this is an advice that we're actually giving all our clients. A lot of our clients, in the thing of succession planning, because they think inheritance tax is going to come, they want to all their assets to their children in their lifetime. And we actually tell them, please don't do that. Because we have seen so many instances of, old people and parents, being ill-treated, or being mistreated just because, they have given up control of their own assets to their children.
Yeah.
I know this to a lot of people who've not seen this. This may sound, something which movies, depict, but trust
alien, but
it actually happens in real life. So in fact, to most of our clients, we're actually telling them the same thing. Try and gift what you can to ensure, that, you do some amount of succession planning, but please keep enough of your assets for yourself that you don't have to ask anybody. You can live your life the way you want to, and then you can just will it, to your children or to whoever else you want to. So it's a very important point you raise. It's very, very relevant for today's times.
Yeah. And I think, along with that is to, like you said, even if you gift some, make sure that you have enough for your maintaining your lifestyle plus contingencies,
Absolutely.
I think
you don't want to rely on anyone for your medical expenses. You don't want to rely on anyone if you, let's say, want to buy a new car. Why would you want to ask anybody money, right? Or if you want to travel or tomorrow, anything that you want to do, you should actually, and especially when you have the money.
Yes,
right? So
exactly.
Depend on your children or anyone. You should always have that independent existence for yourself, and you can always will it, to your children.
Absolutely. Apart from a will, is there any other mechanism through which a person can implement succession planning through their lifetime, during their lifetime?
Yes. So what we typically do is that, we do set up a lot of trusts, for people, families. So mind you, you cannot do away with the requirement of a will, even if you're doing a trust. But a trust basically helps in terms of succession planning of all your assets or the assets, especially your business assets. Because most people, want to set up a succession plan that runs through generations, right? Through the children, grandchildren, great-grandchildren. So what we typically do in such a cases is that we do a trust mechanism, where you have a trustee who basically you put all the assets into a trust, and, and the beneficiaries are your children and grandchildren. And through the trust deed, you typically detail out the way in which you want those assets to be passed on, and also the way you want those assets to be treated and before they are passed on. You can also decide the age at which your son, or the children can get those assets. So this is something which actually is helpful, because then there is no challenge. As I said, a will can always be challenged, but if you do set up a trust in your lifetime, you have a proper mechanism, a trust deed in place, and you've already passed on your asset into the trust, then nobody can challenge that going forward. So if you want a foolproof, mechanism where assets actually, and plus especially if you don't trust your children, you may want to give some things to your grandchildren who are currently minors. And you do not, your son, you don't trust your son, right? Because he's the guardian. So currently he would have access to those properties, and you may not trust him to hand it over. You may not trust to have that business acumen that he will preserve the business. In such cases, you put the asset into a trust, where the bequest goes straight away to the grandchildren. A certain amount of wealth, of course, can keep going to your children. But, the ultimate bequest, like let's say shares of your flagship business interest or an immovable property, the rental income can go to your son. But, the ultimate immovable property will only go to your grandchild post he's 18 or 20 or 30. So, you can structure succession planning in a trust in a lot of different ways, but it definitely mitigates, any challenges that a will may face. It also helps you effectively to ensure that whoever you want that asset to go to can go. And also you can also be a trustee, right? Even if you transfer the trust, you can be one of the trustees. So you still have a certain amount of control, over that asset in your lifetime, at the same time ensuring that it reaches its rightful destination.
Absolutely. No, I think that's very, it's a good way forward for a lot of people.
Yeah.
Yeah. So can I will my property, let's say, to a minor? Both my children are under the age of 18. Can I will them property?
See, you can definitely will the property to them, but what's going to happen is that the bequest will actually go to the guardian, who will hold it, in trust for the children till they are 18 years of age.
Okay.
Because the guardian, in any event, cannot sell any immovable property without court approval. So the guardianship laws are pretty protective that way. But let's assume that if you will shares, or if you will, a certain amount of cash, so nobody really can have control over movable property. So it will of course be held in trust for the minor, but it will of course be operated by the guardian until the minor is a major.
Okay, wonderful. And now we come to the question of the executor of the will. So, a common question is, do they need to be a relative? The other thing is, when we make that determination, I mean, we were discussing that case of where the executor now is in cahoots with somebody, so how do we really safeguard ourselves, in this case? And how do you choose somebody? How do you safeguard yourself with this going forward?
Okay, so to answer the first question, anyone can be an executor. It doesn't have to be
Okay.
someone who's related or unrelated. In fact, it can even be a professional organization. It doesn't always have to be an individual. It can be a law firm, it can be a chartered accountant firm, it can be a friend, philosopher, guide, or legal as anyone. So
Okay.
anyone can be an executor. What we typically recommend is that, see, the role of the executor is the most important one, right? Because the executor has all the powers to deal with your property.
Yeah.
Once you are gone, and until that property is passed on, it is the executor who will file for a probate if required, right? It is the executor who will fight against all the disputes if there are any. It is the executor who will ensure that the asset is actually transferred to the rightful heir. So
Right.
choosing an executor is extremely important. What we typically recommend is that, assuming that it's a fairly clear will and there is an equal division of assets, say between your two children, the
Yeah.
easiest would be to make them the executor, because they are the
children.
ones
Yeah.
who have, yes, because they are the ones who have to gain, and it's basically an amicable distribution because it's equal, so they will work towards that. But that's of course an ideal situation. So let's discuss a less than ideal situation, is where you do anticipate disputes, where let's say one child will not be happy with what you've given to the other child, right? So in
Yeah.
that case, it's always better to appoint an executor who is impartial and who's not one of your children, but could be an elder family member whom your children look up to.
Okay.
Of course, not someone who's the same age as you, because as I said, they have to outlive you, right? To be able to give
Yes.
to your wishes. But most times an elder family member or a family friend, who has certain amount of say in the family, that also works. But other than that, as I said, if you don't have someone you can trust, then please use professional help. Because professionals, the good thing about professionals is that they don't have any interest in your property, right? So they will, of course, just do it impartially. And in your will, you can always give them a certain fee for doing this executor job. For a professional, it will basically just be a job which they will do, so it's not like they will have anything personal to gain. Now,
Right.
the important point, Bhavna, which you raised and which we were discussing, a couple of days ago, is
Yeah.
what happens if the executor is siding with one legal heir and, is actually, being impartial to the other legal heir, or, is actually not giving the other legal heir the rightful due.
Yeah.
In this case, honestly, and I'm very sad to say this, is that the only recourse one has is to go to court. And also the burden of proof, will lie on the legal heir who's actually alleging that the executor is not doing his job. So it will not even be on the executor themselves. You'll actually have to go to court with proof that, look, under the will, I was actually, eligible to get A, B, and C, and the executor has not given me A and B, or the executor is actually colluding and giving what was my share to the other legal heir. So you will have to actually approach the court with proof, and then the court can actually have the executor removed.
Okay. Thank you. I think we're going to start with questions because we've got a lot of audience questions. Actually, the first question that we've come to is the executor bound legally to execute the will in a certain time frame after it has been probated? Can you talk about that? The second part, Nandini, I think she's already answered for you. Can he be taken to court if he's not fair? But is he bound within a certain time frame after it has been probated?
So Nandini, there is no prescribed time frame under law. So once the will is probated, of course, the executor is bound to act within a reasonable time frame, because the court has already actually given a stamp of its approval, and it's just a matter of procedurally getting the assets transferred. So in the event, if the legal heirs feel that the executor, say 6 months to 8 months or a reasonable time frame has passed, and if you feel that the executor is slacking, or he's just not doing his job, then the legal heirs ideally should approach the court to direct the executor to do this in a particular time frame. But in the first instance, the court or the law does not give you a time frame. It's an expectation that the executor, because see, for the executor, this is ideally supposed to be an impartial job, which is not for monetary benefit. So you can expect the executor to act in 30 days or in 60 days, because this is not a job. It's just now in recent times that, people do hire professionals and pay them a fee. But the idea of an executor earlier was not for personal gain. So typically, as I said, a reasonable time frame is expected, but there is no hard and fast law or rule that an executor has to finish this in a particular time frame.
Thank you, Divi. Sangeeta's asking, is a handwritten will acceptable in court? I think you...
Yes, absolutely. Provided, as I said, you have 2 witnesses and you have an executor. Even if you don't have an executor, you definitely need to have 2 witnesses.
Okay, great. We've got some questions. I'd just like you to clarify here at what, from one second, from Krishika, is the granddaughter an heir of the grandfather's assets or immovable property?
So Krishika, is this when the grandfather has died without a will? Or is this, sorry, can you just elaborate in what kind of property? Are you talking about an ancestral property? Are you talking about the fact if the grandfather has died intestate? Let me actually take both those situations.
Yeah,
so
why don't you?
The grandfather has died without a will, then the granddaughter, okay, she's written grandfather's own property. So if okay, fine. So if it's a grandfather's own property, then it's not ancestral property, because it's only 2 generations. As I said, for a property to be classified as ancestral property, it has to be in the family for 4 generations. So if the grandfather has died intestate, then it's not the grandchild, it will be the father, right? The class 1 legal heirs would be basically the spouse and the children who will get access to the property. The granddaughter will not have immediate access, because she will not be a class 1 legal heir. She will likely be a class 2 or a class 3 legal heir. So if the grandchild's parents or father is alive, then the father will get an equal ownership along with his mother and siblings.
Okay, great. Thank you. Then we've got from Raminder, at what age would you recommend will should be made? At what age should somebody make a will? I guess that's what she's asking.
So Raminder, a very important question. There is no age, as I said. As soon as you have certain assets in your name, as soon as you're, as soon as you have a sizable account in your sizable bank account, or you bought some immovable property, you have some mutual funds in your name, if you have a sizable amount of wealth, you should definitely make a will. Nowadays people at 35 and 40 actually are doing really well, and they do have a lot of assets. So in fact, we've made for people as young as 30, right? So there is no particular age, but as soon as you feel you have a certain amount of assets that you would like to leave, to your children, if you're not married, but leave it to your parents or whoever, if you have a sizable amount, then that is the right time to make a will. And as I said, you can keep changing it, right? So it's not like etched in stone that I make this once and I can't change it. So make it once for now, and then of course keep changing it once you get married, once you get children, or however it goes. But definitely make one will for starters.
Okay, and then we come to, let me just, what? Okay, she's asking from A. This is person named A. Thank you, eye opener. Is a nominee enough for FDs, deposits, lockers? Is a nominee sufficient? Yeah.
So see, the thing is that, as I said earlier, a nominee is enough to get the asset transferred to yourself. You don't need to then put a copy of the will. You don't need to deposit a copy of the will with the banks and the fixed deposits. If your name is already there as a nominee, then all you need to do is give your, give the person's death certificate, right? Because the bank already has your details. The only challenge comes is if there is a will and the bequest is actually to somebody else and the nomination is that of somebody else. In which case, the person who's named in the will, their right over the nominee will prevail. But it's much easier if you are a nominee to get the asset transferred, because as I said, then you don't even need a will for that reason.
Okay, great. Thank you for that. We've got from Rinky, what are the rights of a woman on self-made property of the parents? For example, if you also have a brother.
Equal rights. So as I said, right, so class 1 legal heirs is basically gives equal rights to the children. So it's not about, if you are a woman or if you're a daughter that you don't have equal rights as your brother. I know a lot of people, and in fact, this is a very good question, whoever has asked this, a lot of people have, Rinki, that's a very good question. A lot of people have this mindset that we have given enough to our daughters, at the time of their marriage, and therefore everything, should go to our sons, especially the business. Now, when you're doing that as a will, that's fine, because of course it's your choice. But when someone dies without a will, that argument does not stand, because your father may have given, a lot of assets to you at the time when you were married, right? But at the same time, if he's died without a will, whatever assets that he has left behind will compulsorily be equally divided between his wife, which is your mother, your brother, and you, assuming you all are the 3 class 1 heirs.
Wonderful. Thank you for that. From Renu, we've got, are the grandchildren legal heirs if the children are not there? What does that mean?
No, I think what I understood. I understood what Renu.
Understand? Okay.
So let's say if the class 1 legal heir is not alive, then do their legal heirs become class 1 legal heirs? Unfortunately not, because then their legal heirs are actually class 3 or class 4 legal heirs. Because as I said, the first stage is, the immediate children and the spouse. This class 2 would be, I think, your brothers, your father and things like that. And, your children's children, which is your grandchildren, also come in a particular class. I mean, there are around 10 classes. So it's not that you get replaced as a class 1 legal heir, but the grandchildren themselves come in a different class. So it will work as per the class, not if someone has died and their legal heir would take their place. That's not how the law works.
Okay, great. We've got from Praneeth, what about life insurance? I would imagine it goes to a nominee. I don't know.
So same concept, Praneeth. Typically, most of these insurance companies do ask you for a nominee, and they will compulsorily transfer it to that nominee only. But as I said, it's the nominee is actually a custodian under law. So if you have actually willed the proceeds of your life insurance to somebody else, that person can actually, file a claim against your nominee and get it from them. But that's a fairly long and time consuming procedure. So please ensure that whoever you want those life insurance proceeds to go to, please ensure that that person has been named as a nominee in your life insurance.
Okay, then from Rinky, we've got another one. In the absence of a will, if class 1 heirs exist, then does that mean class 2 heirs get nothing?
Yes, absolutely. It goes like a hierarchy. If the class 1 is there, even if there's one class 1 heir, mind you, if there's only one child, there is no spouse and other siblings or anybody, that one child will inherit everything. So you exhaust class 1 completely. Only if there is no class 1, then you move to class
2. Okay. From Samya, in case of 3 sons and the father's inherited property, is willed in one son's name, can the will be challenged?
So the bequest cannot be challenged because, as I said, it's the father is free to will his self-acquired property to anyone he chooses. But if the other 2 sons feel that the 3rd son has forced the father, let's say in most cases we see that there's one son who lives with the father and the other 2 live away, right? And the father has said everything to that son. So if the other 2 sons for any reason feel that the father has been coerced or the father has been forced to will it, then of course you can challenge the will. But as I said, you can't challenge the fact that your father has bequested it to the 3rd son because he's free to do what he pleases with his property.
Okay. Thank you for that. From Vatsala, before we go on, there's somebody messaging me directly. I'm getting 3 or 4 private messages. Could you please share it on the group? Thank you so much. From Vatsala, we've got, when probating a will is not necessary in a state, can a government official ask for more documents for transferring the property to the beneficiary, or just producing a will is enough?
No, so unfortunately, as I covered this earlier, what happens is that if a will is registered, then yes, they ask for lesser documents because that's still enough proof that the person has, actually signed the will or, by themselves. But if it is an unregistered will in a state where probate is not mandatory, let's take Delhi, for example, then yes, regulator typically always will ask you for more documents because they don't want to be caught in a situation. They don't want to be part of a legal dispute. That why did they transfer the property to a particular person and not, to somebody else, although the will may state that. So what they will typically do is they will ask you for NOCs, if there are any other legal heirs. So let's say if there are 2 children and it's bequeathed to one. They will typically ask you for an NOC from the other one. They will ask you to give an indemnity bond, which is valid for a time, that if there is a dispute, then you will of course return the asset, or you will, indemnify them. So there will be certain other documents. There is also one piece of law that I want to point out. In a mutual fund, if the value of your mutual fund is above 5 lakhs and there is no nominee, then you compulsorily need a probate for your will. Because that is the mutual fund law, where the portfolio is really high, then they will request for a probate if they don't have a nomination. So again, that brings us to, the question that please ensure that your nominees and the bequest in your will are aligned. It just saves you a lot of trouble.
Okay, great. From Paru, she's messaged me that in the case of a divorce and the children are living with the mother, do the children get rights over the father's assets, or will it go to the father's siblings or his own father?
So if the father has died intestate, then the children continue to be legal heirs.
No. In the case of a divorce, if the children are living with their mother,
so the father has died without a will.
Okay, in the case of fine. Please carry on. Sorry.
If the father has died intestate, the children will continue to be legal heirs. The mother will not, because she has legally separated. So she is no longer a spouse within the meaning of law. But the children will continue to have a right, and they will be the class 1 heirs, even in case of a divorce. Unless the father has, publicly disowned the children, or, filed a public notice saying that I have nothing to do with them and they're not my legal heirs anymore, which most people don't do. But unless he's taken the legal route of disowning them as legal heirs, the children will continue to be class 1 legal heirs, and the brothers cannot get a right.
Okay, fine, perfect. Thank you. From Nimisha, if the father has not given will to his daughter, probably not willed something to his daughter, but only to his sons, then is it possible for a daughter to challenge that will?
No. So as I said, if it is self-acquired property, one cannot challenge the bequest, right? Tomorrow, even if I will everything to my servant, my wife and my children cannot challenge that bequest. At best, what they can challenge, as I said, is if you feel that, your brother, has coerced your father to do, to sign that will, or has fraudulently, managed to get your father to execute the will, you can challenge that. But you cannot challenge the bequest if it was your father's self-acquired property.
So Nimisha, this question, like Divi's just clarified, I think it goes back to source. Where did the properties come from? That would really be the way to, right, to be able to answer that for her. From Rinki, we're continuing her first question. If the daughter challenges the will, how long does it take to get a judgment in these cases? And her second part is mediation used most commonly in inheritance cases, or is going to court better?
So to answer the first question, I don't have an answer. It typically takes anywhere from 8 to 10 years to get a judgment. Wow. But also, as I said, what we typically see in most of these cases is that the parties actually reach an out-of-court settlement, because no one then has access to those assets, right? Because you can't alienate those assets and things like that. So typically, yes, I cannot answer how long a judgment takes. It would take years. Be mindful that, it will take a long time if you actually go the legal route, because any kind of dispute takes very, very long to, actually get resolved. So 8 to 10 years is something that it would take. Mediation, of course, is always a better option for any dispute, not just, a will or inheritance related dispute. Unfortunately, mediation initially works out very, very less. There are very slim chances of an initial mediation working out. But yes, as I said, if you are going to go through the dispute route, you can at best hope that, 2-3 years down the line, when the parties have actually realized it's futile to fight, let's reach, a settlement, then, that actually is a better approach, because then you can easily file consent terms and nobody can back out, because those are consent terms which are approved by the court. Right? So let's say you reach a mediation agreement and you agree to withdraw the suit. Then you file your consent terms that, okay, fine, you take 60%, I take 40%, or things like that. And then at least you have access to those assets, and you don't have to wait for a 10-year, long journey, or a 10-year waiting period in court.
Thank you, Divi. From person A, how would I leave a property to a spiritual trust for a deal that they would use it in a certain way? Is it through a will?
Because actually I had not touched upon conditional bequests, but conditional bequests are actually very, very valid under law. So you can actually will it to a spiritual trust with certain conditions, that you would want the property to be used in a certain way, as you said. And in the event if they do not use it in a certain way, then of course, they have to return it, or, you can, come up with an alternate bequest. You can come up with an alternate beneficiary. The only challenge here is that then somebody has to keep track of how that property is being used, which typically nobody does. So then, because once you're because then, as I said, the entire burden comes on the executor to ensure that these conditions are being met. So in all probability, some of these are not even upheld, because your executor is not someone who's going to, ensure that, unless it's a very, very close family member. And also, even if your executor does see that the trust is not using the property in that way, to have them transfer it to your other beneficiary is not going to be easy, right? No spiritual trust is going to just put their hands up and transfer. So again, then your executor has to use the court route. So as I said, so don't make things that complicated. Then maybe what you can do is look for a way around that, or also at the same time try and keep conditions, which are as simple, which is easily doable, by somebody. Because otherwise, for someone to ensure that your conditions are fulfilled, or if not fulfilled, then to ensure that the asset goes to somebody else, it's practically very, very difficult to implement. You can put conditions, they are valid, but they are also difficult to implement in the long run without interference of the court.
Thank you so much, Divi. We've got one last question. This is the last question I think we'll take for the night. Okay, we'll take two more and we're closing now. If property is transferred without NOC from the other heir, can it be challenged? From Sangeeta. I think if you've got your NOCs, then can it still be challenged?
See, a challenge can happen at any point, right? And it's not only, as I said, with respect to a will. Anyone can file any kinds of claims, any kinds of challenges in court. And people do that all the time. There are frivolous challenges also. Then, of course, it's up to the court to decide whether the challenge has merit or not. It does not stop your right from challenging. So tomorrow, even if you may have given an NOC, you can always challenge and say that, look, I was misled. The facts presented to me were not what they turned out to be. Or you can always say that, that this NOC was actually not signed by me. So there are, of course, ways to challenge. But also at the same time, as I said, it is up to the court to then decide, whether your challenge has merit or not. There are cases which are actually not even admitted. They are just thrown out from day one because the court feels that your challenge has no merit. So it actually really depends on your kind of challenge, your reasoning that you're giving for that challenge, and if the court think there is any kind of a merit to actually listen to you further.
Okay. Thank you. We've got one more from Rinky. If the father wills to the son, can the daughter make a claim on an HUF property?
Yes, because as I said, the HUF property is not the father's property to will. So in fact, now there has been an amendment in 2015 where daughters have an equal right in an HUF, right? So earlier daughters, the minute they got married, they immediately had gotten out of the HUF. They were immediately not a part of the HUF. But by way of that 2015 amendment, daughters have an equal right in an HUF property. So typically, firstly, the father cannot will the property because the property would have equal shares between his spouse and his children. So in any event, he cannot will that. And secondly, the daughter can still claim a share because now she's the rightful owner of under that HUF under law. So ideally, then the share would be the mother, the brother, and the daughter in equal shares.
Okay, wonderful. Thank you so much, Divi. It's been a great conversation, and we really appreciate you coming on and sharing. I think these are not easy topics to digest, but you've broken it down and made it very accessible to everyone. So really grateful to you for that. Next week we have with us Mr. Ajay Behel of AZB and Partners on the 25th. On the 26th, we have our organ donation event. Please do join us again next week. We look forward to connecting with everyone. Thank you so much, Divi, once again.
Thank you, Bhavna. A pleasure. Thank you.
Thank you.